All right, today we're going to be talking about Nebraska's 3-day notice. It's more commonly called a 3-day notice to pay or quit. Now, before you go any further on this video, down below into the remarks, I'm going to have a link where you can actually download the 3-day notice because I want you to have it in front of you as we go through it. So I'll give you a few moments. Go ahead, go to the link and then print the notice. The 3-day notice, a couple of things before we get into the math of it all. This notice is used only when a tenant does not pay the rent. That's the only time we use the 3-day notice to pay or quit. It's a notice, it's a legal notice required by the statute that says, Mr. and Mrs. Tenant, you have 3 days to pay your rent and other amounts that are due, or otherwise I, the landlord or manager, will terminate or quit our relationship and proceed with the eviction. So it's a very important legal step in the process. So if you have it in front of you, I want to go through this. Now this is the NebraskaLandlord.com 3-day notice. You're more than welcome to use it, but before you do, I have to give the disclaimer, make sure that you have your attorney approve it. But let's read through there because there's some things that I really want to point out. If you notice at the very top, it says the 3-day notice to pay and intention to terminate the lease agreement for non-payment of rent. Notice it's in bold, capitalized lettering. That's important. In the legal field, when we want to place emphasis on something, we do things like underline, bold, use capital letters because it's a higher emphasis or a point of contention. You'll notice actually one little thing, it says the numeric value 03 and then it spells it out 3-day notice. I actually did that intentionally. Several years ago I was doing an eviction and a judge was really looking for a reason to toss this thing out for whatever reason, and because I didn't have the numeric value and I only had 3-day notice, she threw it out and made me start over. So a lot of this is through trial and tribulations. All right, let's continue on. It says this legal notice, remember it's a legal notice as required by the statute, time is of the essence. Failure to comply with this legal notice may result in legal action against you. It says consult with an attorney if you do not understand. Why this is in here is we don't want to give any affirmative or any potential legal defenses to the tenant. One of the things the tenant may be able to do if you don't have that verbiage in there is show up and go to the judge. Listen, I didn't realize how important this was. If I knew it was a legal notice, I would have consulted with an attorney. And again, we're removing that one potential affirmative defense that the tenant may be able to use to try to postpone the eviction. Again, looking at your 3-day notice here, notice that I have 2 columns. There's an itemization of the amount due and then the total. You can only collect or go after or ask for the amount that you're entitled to. So let's say the tenant is 2 months behind. Let's say they didn't pay February and March. We need to make sure that we actually list the total amount that's the rent that's due for each one of those months. So we're going to do February, $500, March, $500, and then any corresponding late fee. Because if you don't put it on this, you can't go back later and ask for it. So whatever monies are owed and whatever monies that you want them to pay, you need to make sure that it's in here. So we break it down itemized by itemized deduction, and then we actually have the total amount that's due, as you can see in the second column. And then we sign it. Here's the thing to remember, down in the bottom right-hand corner here, this is very important. It says delivery, hand and mail. However you deliver this notice is very important, and it's right here on the notice that we have to make an affirmation of how we did it. If you hand delivered it, then we're going to check hand delivered, the date that we hand delivered, and who hand delivered it. You don't have to. Maybe it's your maintenance person, okay, or your secretary. That's fine. It doesn't matter who delivers it. We just need to make sure that it's noted on the notice. Let's say you mailed it. What date did you dump it into the mailbox, and who did it? So we want to make sure that that's on there. Okay, very important. Again, we're trying to remove any potential legal defense that a tenant may have. So a couple of things about delivery I want to talk about, and I've discussed this in a previous video, so I'm not going to spend a lot of time on this, but it's very important to understand when you're mailing this, only mail it first class. That's it. Do not send this notice registered or certified mail. One, it's not required to be according to the statute. The other thing is the courts have already decided that first class mail is sufficient for delivery. What happens legally is if we send it certified or first class or registered mail, then we're basically volunteering to a stricter delivery method. And therefore, because we did that, then the tenant can walk into court and say, I never received it, because we know that when the post office delivers that little tan card to your tenant saying, hey, you need to pick up something at the post office, they're not going to come and get it. So again, don't put yourself in that position. First class mail. The other thing is, if you're going to hand deliver this, tape it to the door and then take a photo with your cell phone. You can use that as evidence that you delivered it. All right, the next thing I want to talk about, this 3-day notice here. The math, the timing is very, very important here. All right, so let's say that the rent is due on the 1st of the month. All right, they have the first till the end of the day to pay it. One of the things I like to put in my lease is a time. So rent is due on the 1st at 5 p.m. You don't have to do that, but that's something to consider. But let's say it's due on the 1st and they don't pay it. On the 2nd, they're now late. So on the 2nd, we're going to send, or what we call serve, the 3-day notice. All right? This is called the service day. We cannot use the 2nd of the month as the first day of the notice period. So we have the 3rd, we have the 4th, and then we have the 5th. Okay, these are days of the months here. So it was due on the 1st, they didn't pay, so on the 2nd they're now late. So what we did is sent them the 3-day notice. Hand deliver, mail, it doesn't matter. This is the service day. We cannot count this. The 3rd, 4th, and the 5th is the 3-day notice period. All right? If on the 3rd, 4th, or the 5th, your tenant pays the amount that's owed to you in full, i.e. whatever you indicated on our 3-day notice, they come into your office and they pay it in full, you must accept it. You can't say no, okay? Let's say they come in and they're $200 short. Well, it's not the total amount that's on your notice, so you can say no. In fact, if you accept a partial rent payment, what you're doing is risking the fact, basically what it does is if you accept anything other than the amounts that's due, let's say it's $500 and you take $250 with a promise in 1 week from the tenant that they're going to pay you, and that following week they don't pay you, you cannot evict them for that month. You have to wait till the following month to start the process over again. So you have to make a business decision how you're going to do that. Point is, here though, during this 3-day notice period, if they give you the entire amount that's indicated on your 3-day notice to pay or quit, you must accept it. Let's say on the 6th, of the month, they don't pay. So during the 3 days, they haven't paid you. It gets to the 6th of the month. Now what you're allowed to do, this is where we terminate the lease agreement. Now you terminate it as the landlord or the manager. That's your prerogative to do. So on the 6th of the month, they still haven't paid, or maybe they came in with a $200 short and you said, nope, I'm not going to accept it. Well, now you can terminate the lease agreement and start with the eviction process. One of the common mistakes that I see landlords and managers do is they try to shortchange it a day by counting the 2nd of the month, or that service day, as the first day of the 3-day period. If you do that, you're giving your tenant an excuse to be able to go in front of the judge and postpone the eviction by an entire month. So anyways, I hope you learned something. Please, at the bottom of this posting here, please leave your comments, ask your questions, share this with colleagues and fellow landlords and property managers. Until next time, I'm Paul Vacheski with the NebraskaLandlord.com. Manage yourself, but never alone.